ICC in March 2019, while the court authorized the start of the investigation on September 2021. The defense team's move comes 4 months before the confirmation of charges, hearing set by the court. Let's get on point with ICC Assistant to Counsel, Attorney Cristina Conti. She joins us via Zoom. Attorney Conti, welcome to the show. Thank you so much for your time.
Thank you.
Let's talk about the strategy of the defense, basically saying that the ICC has no jurisdiction because the investigation on the crimes against humanity had begun when the Philippines had already left the ICC. Number one, were you surprised that they questioned, first and foremost, the jurisdiction of the ICC?
Well, no. They've been at this since day one. They've said that, the ICC has no jurisdiction. And it took them about a month and a half to formalize this question or challenge over the jurisdiction. It is no surprise as well because this has been previously raised by the Philippine government in their submissions regarding the deferral of an investigation. But for us, there already has been clear direction or indication about this matter, and it is that the ICC retains jurisdiction over any matter under consideration by the court, even after it has withdrawn. And they're talking about specifics, investigation, and we'd also like to raise that the court, through the Office of the Prosecutor, had already opened a preliminary investigation in February 2018 before we withdrew. And so that's going to be the two contending positions in this challenge.
Attorney Conti, there are two words here that are normally or often interchanged. It's preliminary investigation, and what's the other one?
Oh, it's preliminary examination.
Examination.
The other one is investigation.
Okay.
We're familiar with this because in the Philippines, it is preliminary investigation, PI. In the ICC, it's split up. It's PE and I.
What does preliminary examination exactly mean? Does it mean that it is the beginning of an investigation?
Essentially, in a sense, yes, because the ICC will be looking more closely into a situation. That's what they call it. It's not yet a case. It is a situation where they will look and answer the question, to be simplistic about it, are there crimes committed in the territory which are covered or within the scope of the authority of the ICC? They're going to look at, are these murders part of a widespread and systematic campaign? Are these attacks against the civilian population? So clearly it is, quote unquote, and in a generic sense, it is an investigation into the situation.
But why would they use these words separately, which is now causing, well, for someone like myself, a bit of confusion, because this is something we've discussed over and over again, and that this is the same discussion that is being used to actually tell or use as defense that wala na po tayo sa ICC nung nag-umpisa yung investigasyon. So when you said that, what happened in 2018, did you use the word examination or investigation?
Preliminary examination was begun in 2018. It talks about what are the crimes committed in the territory. In 2021, the next stage or the next step was to determine who were responsible. So the first step talks about what crimes. Second one, who are most responsible. So there's a little bit of discussion as well as to another term. This is another phrase. Please say with me. So there's another phrase in Article 127. This is the provision that deals with withdrawal. And it talks about any matter under the consideration by the court. And this is hotly debated in this submission by the defense. They're saying, how do we interpret any matter under the consideration of the court? Because the law states, the Rome Statute states that if there is any matter under the consideration by the court, it will continue to be considered by the court. And so they're talking about, is this matter a preliminary examination or should it be an investigation? The difference between the examination or PE and the investigation being the preliminary examination is started and is conducted by the office of the prosecutor, not yet by the quote unquote judges. So the pretrial chamber or whichever chamber of the court. It is only during the investigation phase that the judges are called in to affirm or to ratify the opening of an investigation. It's a little bit different from the Philippine processes. So a bit complicated, but essentially they're talking about what matter is under the consideration of the court at the time we withdrew. We say that the matter is preliminary examination opened by the office of the prosecutor. The defense now says, no, that cannot qualify because it has to be a matter tackled by the judges because
Under
we're
the
talking
pretrial
about the court.
chamber.
Yes, we're talking about the court, capital C. And when you say court, it has to be judges. It cannot be just the office of the prosecutor. But we disagree with that position, of course.
Let me summarize that again. In 2018, the preliminary examination began.
Yes.
That this is the what it answers the question on what. In 2021,
crimes are being committed.
what crimes were committed? That's right. In 2021, that was the preliminary investigation. And
The
this,
investigation.
investigation. And this answers the question, who was responsible? Who were responsible
Who were. So
for
it's
the
a little
crime?
bit grammatically challenged because they talk about most responsible, but it could be a group of people.
Right. And of course, that's subject to further maybe arrest warrants that may be issued. If that's the case, it becomes were. But between 2018 and 2021, there is a provision which you had mentioned a while ago that is under consideration of the court. And you say that the under consideration of the court should be, since 2018, the start of the preliminary examination. But the defense says we disagree, and under consideration of the court should begin or should have begun in 2021 when the investigation started. Did I understand that correctly?
Yes, precisely. There's just this other phrase, any matter under the consideration by the court. So, I mean, what? Meaning, is this matter either a preliminary examination or an investigation? And consideration by the court. So, this phrase is being actually minutely dissected by the defense. And we hope that the Office of the Prosecutor can counter this with similar research.
We have a graphics also to also help our viewers kind of understand and digest this. This is coming from a report a while ago from Hannah T. It's a timeline, a very short one, a timeline of when we joined the ICC. I hope we can show that on air. November 1, 2011 was when the Philippines joined the ICC. March 17, 2017 was when we filed a notice of withdrawal, which actually takes 1 year after to take effect, a year after there. So it took effect at 2019. Ito po yung sinasabi ni Attorney Conti that in 2021, the investigation started or was authorized. So this is the exact defense that the defense is using, saying to point out that the ICC has no jurisdiction.
Yes. Of course, they would skip February 2018. This is the date that the prosecutor opened a preliminary examination into the Philippines.
Yeah.
That's the first step in essentially in a situation.
In an investigation. To
in a
even
generic,
start.
yes,
Yeah.
in a generically what we call an investigation.
But if this is
So,
the process, Attorney Conti, here's what I need to understand. If this is the process in any other case that the ICC tackled, it started with an examination that eventually led to
an investigation.
an investigation that was authorized. So were there precedents of the same nature as this or that of former President Rodrigo Duterte?
Well, there's nothing of this sort so far in the ICC because we are the first. Well, we're the second state to have withdrawn from the ICC. But in the previous case of Burundi, the investigation had been authorized before they withdrew. And so we're in a situation where this is a case of first impression,
Okay.
where the judges could rule either way, and it could be valid and would have impact on other cases.
Is this
So
concerning though?
yes, it's concerning because it's going to set the pace. It's going to set the tone, rather. It's going to set the tone for other investigations that might come in. And in the case of Palestine, their situation, although it's a little bit different, they have had also questions about jurisdiction, because Palestine first accepted the jurisdiction of the court by this is through Article 12. You accept the jurisdiction of the court only after did they sign the Rome Statute. So there's a lot of gray areas apparently as regards when when does the ICC have jurisdiction. And for many, it's been clear. Even the defense admits this. What is the jurisdiction of the ICC? It has jurisdiction over crimes committed by during the time that
The country was still a
is a
state
member.
party.
So it's
Yeah.
clear. However, they make a distinction. They say that, so the Philippines clearly was a member of the ICC when the crimes were committed. But now they say the exercise of jurisdiction is different. And there would come a time that, so in the Philippines, let's say it's clear, right, that the Philippines was a member when the crimes were committed. But because of some lapse in the processes, we as Filipinos cannot invoke the ICC's protection or judicial authority. Because of this, I would even say this a technicality. And that would bode differently for other members already of the ICC.
What is mind-boggling for me, attorney, I'm sorry to cut you there,
Sure.
is that if there is such a thing as, obviously, as there is factually, a preliminary examination and an investigation that is authorized, it can happen that once an examination begins, any country that is a party to the Rome Statute that makes you a part of a member, a part of the ICC, can easily just say that I choose to withdraw from the Rome Statute, get out of the ICC, and then it will be up to the prosecutor to actually finish the examination within a year's time. Otherwise, it'll set a precedent that in any country of any leader, for that matter, who may be alleged to be guilty of any crime, ang gagawin lang po nila, aalis na lang po sila, because it doesn't seem like the examination can be done in a year, because as pointed out here, it started in 2018, but the investigation actually began in 2021. That's 3 years.
That's precisely right, Pinky. That's the mischief that the ICC Rome Statute has actually tried to prevent. So, first, apparently it would turn out to be ineffective if the judges rule in the favor of the defense. The judges said that, it's a clear way out if the country withdraws from the ICC, and therefore we will have the effectivity of the withdrawal 1 year after. But then the interpretation would be now the Office of the Prosecutor is pressured to finish within 1 year, when in other situations, a preliminary examination can take years, can take even, I think, 13 years in the case of Palestine. So,
And I
this
guess
is
as
going to
proven
be a
here, it took
question.
3 to 4 years, attorney.
Yes, yeah, actually. So it
Wag na po
really
tayo
would be
lumayo.
a test. It would really be a test of the ICC's effectivity. Kumbaga, kung ganun pala ang mangyayari, di hirap na hirap at magkukumahog yung prosecutor lagi. At kailangang magbukas siya ng preliminary
And
examination.
nakasalalay
dun
po sa kamay niya.
binubuhan.
Kasi dapat in
Parang
1 year,
ganun.
magkaroon na po ng authorization on an investigation.
An investigation before yung withdrawal.
Before.
And this is what we're pointing out as well. The Office of the Prosecutor is an integral part of the ICC. Hindi po siya hiwalay na institution, walang nag-create na separate law. It's the same law. The Rome Statute created the Office of the Prosecutor as well as the judiciary. And therefore, when we say the court, it could also pertain to the office of the prosecutor. And when it begins a preliminary examination, that's the ICC in action already. And we cannot put, strict time limits as to it and say that, well, they should have had until March 16, 2019 to finish its investigation or examination rather. So no, let's not create alternative definitions or converse implications for the Rome Statute. The Rome Statute says that withdrawal takes effect after a year, and even after you have withdrawn, if there is any matter under consideration by the court, it should continue to exercise jurisdiction.
This is going to be a very important decision by the pretrial chamber on how they will actually decide on this motion. Would that be correct? This motion by the defense that this document called Defense Challenge with respect to jurisdiction. So this was filed, I believe, May 1, more than a month after the former president was turned over to the ICC. Ito pa lang po yung una. I would just want to go very quickly. I hope we still have time for this. Just very quickly. Just an update. I have 2 minutes left on the... Totoo ho ba yung sa victims? There was a story on only a government ID, such as a passport or an SSS card will be allowed for them to submit so that they can be acknowledged as alleged victims of the war on drugs. What's the latest here?
Well, it has to be clear. First, there was an application by the Victims Participation and Reparations section to admit up to 30 government-issued identification documents. The defense asked or suggested, or however they call it, they said observed, that first primary should be, why not just require a national ID or a passport? In the alternative, maybe some of the other documents is indicated in the SSS. When the court ruled, they favored the VPRS or the earlier submission of up to 30 different documents.
Okay.
So this is a bit, to be technical about it, splitting hairs. So we're actually talking about, from both parties, government-issued documents.
All right. So I guess, just as a last question, any idea on this motion that was submitted by the defense? Because if this is ruled upon, I guess my question is, can this be ruled upon even before the confirmation of charges in September 23?
Yes. The defense actually asks that it be resolved before the confirmation of charges or before we talk about the merits of the case. Although the ICC pretrial chamber can rule two ways. One, it could say that we will rule on this, we will call for a hearing on this matter, or we will talk about this at the same time that we tackle the confirmation of charges. So we're waiting for this decision on the conduct or how